Well, an exit or severance package offer is usually made to the employee with the condition that they enter into a settlement agreement, which will require them to give up all of their legal rights to pursue their employer for a claim or claims in the employment tribunal, including any claim for contractual entitlement to notice pay, bonus, shares, share options, commission, accrued holiday, and settle any unlawful deduction of wages claims, unfair dismissal, and discrimination claims, to name but a few. Well, first thing, you need to establish what their notice entitlement is, and you'll need to check whether their contract of employment has a notice of termination clause in it. It ought to, and whether that notice is less or more than their statutory notice entitlements. If it is less than their statutory notice entitlement, for example, that they are only entitled to 1 month's notice under their contract, but they've been with you 12 years, then actually they're entitled to 12 weeks notice. Now, there may be a payment in lieu of notice clause, often called a pylon, P-I-L-O-N, in their contract. And if they do, this may enable you to terminate their employment contract without notice, but pay them in lieu of usually basic salary, or perhaps, depending on how it's written, benefits value as well, instead of giving them notice and having them work out that notice period on your premises, or perhaps being placed on what is known as garden leave, where the contract of employment continues, but where they essentially work it out at home. That means they're still employed and serving notice, but at home in a non-working capacity. Well, if their contract doesn't contain a pylon clause, then you can terminate their employment, but will have to pay them the equivalent of what they would have earned and received in benefits and salary during the notice period. Otherwise, you risk facing a breach of contract claim in the court if you don't do that. This is known as a wrongful dismissal claim. They may be entitled to receive all or part of any bonus or commission payments as part of their severance package. This is subject to their terms of the employment contract, which may say that they have to be in employment at the time that their notice is given and not under notice of termination when the award is made and paid. Now, often employees will claim for bonuses that they would have received had they worked their notice period. You need to check what the pylon clause says about that and what the bonus scheme rules say about eligibility for payment of bonuses. Now, in the event of a discretionary bonus arrangement, if the bonus has been paid out consistently in preceding years to people who have left and who've met the specific targets, the chances are that there's a very good argument to say that this bonus should be paid to this particular departing employee under the settlement agreement. Well, if they've been given some shares or options or participate in a share save scheme, then how these are treated on termination of employment will be determined in most instances by the scheme rules. It's important to establish whether they're going to be treated as a good leaver, because frequently there will be provisions that are beneficial if they have a good leaver status, such as market value for their shares as opposed to the nominal or awarded value. And good leavers are usually those who have to retire due to ill health or age, or are made redundant, or have resigned because of their employer's breach of contract, often called constructive dismissal. If they simply decided to leave, then they may be classed as a bad leaver if they're not leaving under circumstances which would amount to constructive dismissal claim, or they're not leaving because of ill health or redundancy. Well, there are two types of compensation that they could be looking to be compensated for. The first one is compensation based on length of service, age, and current statutory minimum weekly pay, which is currently £571. And this is known as the basic award, and it's calculated in the same way as a statutory redundancy pay, and it's up to a maximum of £17,130. So, assuming that you accept, for the purposes of settlement negotiations, that in all probability they will be dismissed if they don't accept the offer unfairly, because you haven't, for example, taken them through a set of warnings, then the likelihood is that they're going to be looking for a basic award in terms of compensation in addition to their notice period. They might also be looking for what is known as compensation for loss of earnings. But you do need to be mindful, however, that compensation for loss of employment for unfair dismissal is currently capped at £93,878 or a year's loss of earnings, whichever is the lesser, so it's whichever is the smaller. So for example, if the employee's annual salary is £65,000 and you're thinking of making a compensation payment to them, the maximum that they would hope to recover in the employment tribunal, if they were to pursue a claim for unfair dismissal only, would be £65,000 for loss of employment. Well, yes, if they've been subjected to unlawful detriment for example, asserting a statutory right, such as the right to be protected in terms of health and safety, or asserting a health and safety right as it's commonly called, or perhaps for whistleblowing, or discrimination for a protected characteristic such as age, sex, disability, race, or any other protected characteristics, then the cap of 93,000 doesn't apply. Ultimately, your negotiating power around compensation for loss of earnings needs to focus on how long it will take for them to secure new employment. Against this, you need to be pragmatic, as there is a statutory obligation on them to mitigate their losses once their employment with you ends. Well, the best way to proceed is with a protected conversation, which is allowed for under the Employment Rights Act 1996. And it was allowed for since 2010, when Dr. Vince Cable, who was the Lib Dem business secretary under the Conservative Lib Dem coalition government, introduced a number of measures that were designed to ease the burden on employers. And he came up with a protected conversation and a settlement agreement route. Now, what this means is that as an employer, you can conduct a protected conversation with an employee to suggest a managed exit on financial terms, and crucially, it has to be on financial terms that would include at least notice and some form of reasonable compensation inducement for them to leave your organisation under a settlement agreement or through an ACAS form COT3, which is another form of settlement agreement which is reached through ACAS. The reason why it is a protected conversation is that if it is intended to settle the employee's rights and there is no duress or improper pressure, then the employee cannot refer to the employer's offer in any unfair dismissal claim in the employment tribunal. If the settlement negotiations break down, and if they do refer to the settlement offer, then the tribunal will disregard it. However, specialist advice is required if these conversations are to be conducted, where the employee could bring discrimination claims instead of, or in addition to, unfair dismissal claims, because the employee can refer to such conversations or settlement offers in connection with discrimination claims.